we have a unique interpretation of the laws of New York State. I would ask, I see some glaring omissions in your presentation, and I would wonder if you could explain to us, some of the omissions are New York State Town Law 264 and 265. You didn't touch on those, but what I'd really like you to explain to us a little bit about the 1981 memorandum that was sent from the DEC to the governor to clarify that the DEC did indeed intend to supersede zoning.
Are those the end of your questions?
Yeah.
All right, so, may I answer hers first? Sure. So, the first question is talk about, New York State Town Law 264 and 265. I'm going to talk about one of those. I'm not going to talk about both of them in this venue. One of those only applies when you're doing a zoning amendment. So it does not apply no matter what Mr. Slottje says or anybody else. It does not apply in a zoning unless you're doing a zoning context. I'm answering your question. Okay. The other one, if this board or the village board of trustees decides to engage us, I will explain to them why the other one doesn't apply. But I am not in a million years going to explain it to you. I will tell you that it's come up, we've done over 100 of these, and you can laugh, but nobody's sued yet. It does not apply if you do the law the right way, but I'm not going to explain why. The second question is, this is an example. This was specifically rejected by the court in the Middlefield decision. Mr. West, so I guess he was helping in Middlefield because it wasn't in Dryden. Mr. West thought that he found a so-called smoking gun. And the smoking gun that he thought he found was basically the equivalent of an opinion letter from somebody in the DEC, somebody very senior in the DEC. Let me back up actually. In the papers that were filed in the first two cases before this, they filed an affidavit from a guy named Commissioner Sovis. And Sovis was the former #2 at the DEC. And this affidavit at the basically said, I was, at the time of this law, ECL 230303 subsection 5, I was the #2 guy at the DEC. I essentially wrote ECL 230303 subsection 2. And here's what I intended. And what I intended was that the localities have no authority and that we're going to supersede or preempt their authority. So they filed that affidavit. People came to us when they saw the papers and they said, oh my gosh, what are we going to do? We said, it's nonsense. It's legally irrelevant. Yes, we did. Now let me keep going. So the judge, it turned out, it was briefed in both cases, the judge specifically said, and I'll tell you why in a minute, that it's legally irrelevant and we're not going to pay any attention to it. It was briefed, and the judges are not idiots, and they did not ignore it and they didn't miss it.
That wasn't
and the reason I understand, Mrs. Dorsey, and it's the same, let me finish, please. And the principle of law, the reason we were able to say that it's nonsense and that it's legally irrelevant is that as a matter of law, black letter law, what the legislature says, what the DEC says about the interpretation of the law is legally irrelevant in this sort of thing. In our constitutional set of government, we have something called the separation of powers. And the legislature is the one that decides what's going to be in the law and what's there. The executive branch executes, and the judicial branch interprets what the law says. So the opinion of the DEC, which is the executive branch, as to what the legislature was thinking about when the legislature passed the law, even though the guy from the DEC said that I really wrote it, is legally irrelevant. Now, the same issue came up on this so-called smoking gun. The judge, just like almost virtually everything in Mr. Wedlake's presentation, the judge, Mr. West, went back to the judge on this one and tried to reopen it. And the judge said two things. A, it ain't no smoking gun. And B, it's legally irrelevant. Now you can shake your head, but I've been reading the law for 31 years. And that's what it said. So that's my answer.
Well, you did.